Welcome to the FloridaDefense.com podcast. With over 30 years of strong defense and over 30 years of even stronger results, with FloridaDefense.com, you'll never believe you can't win.
All right, welcome to the Bauer, Kreider, and Perry Criminal Defense Podcast. We are speaking to attorney Mike Kinney.
Hello.
All right, how you doing this morning, Mike?
I'm doing really well. How are you?
Good. Well, you've had an interesting case a few weeks back that we want to go ahead and talk about this morning, correct?
Sure.
Tell us a little bit about that.
Well, in Florida, there's this statute called a sexting statute, or the sexting statute. And that statute was enacted, I'm sure about when I say the word sexting, everyone probably has an image or an idea what we're talking about. Right. But that statute was particularly put into place because of this. I guess ostensibly there was a lot of concern about young folks sending pictures that obviously are, quite frankly, end up being very regrettable pictures in the future. Pictures of nudity to other young people. In certain cases, they get exploited and lives get turned upside down. So before the sexting statute was enacted, and that was around 2011, the only crimes that would capture that type of act, which is taking a picture, a sexually related picture or a nude sexual picture, and send it to another individual. The only charge available would be an exposure of sexual organ charge or a lewd or lascivious exhibition charge, and those charges can be life changing. If someone's charged with a lewd or lascivious exhibition, it's a felony. And it's something that might require a person to spend the rest of their life being marked as someone with a sex offense, and that's just not something that folks want in this world, especially when we're talking about teenagers. So the Florida legislature, in an effort to try to circumvent that unfortunate result, decided to make a law applicable to teens only, or teens or minors only. And the idea was anyone who was caught sending a sext message, which is a message of a sexually provocative nature or sexually related nature to another individual, and if it's a juvenile, for a first-time offense, it would be almost like a non-criminal event. You'd pay a fine, have to do some community service. So the intent was, I would say that the intent was good. The intent was designed not to ruin the lives of kids who probably don't always have the benefit of thinking ahead. And it was a laudable attempt. But what happened was, with the way they wrote the statute, what wasn't considered was where they were going to be able to prosecute those types of cases. So in the state of Florida, juvenile cases only have two places that they can be prosecuted. There's two types of courts. There's the circuit court, and the circuit court is the top trial court in the state of Florida. And then you have the county court, and that's kind of the lower trial court in the state of Florida. For all juvenile crimes, the only jurisdiction, no matter what the crime is, whether it be a felony or a misdemeanor, is circuit court. It would be actually in juvenile court. And those cases actually start off in re, or in the interest of, and it has the child's name, and all that stuff is actually confidential. County court is the only other court where there's a jurisdiction on a juvenile charge, but that's involving traffic violations only. So, for instance, if a 16-year-old is driving and he's speeding, he gets a ticket, and he wants to contest that ticket, he would contest that ticket in county court like any other adult would contest their ticket. That's the only time a juvenile can be in county court, is if he's dealing with a traffic offense, whether it be a civil infraction or even a DUI charge, a criminal traffic charge. So the way this statute was written, however, it expressly tells you that a sexting first offense is not a crime. So if it's not a crime, the problem is the circuit court, which handles all juvenile criminal matters, cannot prosecute the case because it's not a criminal act. And if it's not a criminal act, the circuit court doesn't have jurisdiction. The other issue that comes up is the only other court that the case can be prosecuted in would be county court. And because it's not a traffic offense, the county court does not have any jurisdiction. And it's just a weird thing about cases in general. A court has to be granted jurisdiction by the state in order to have jurisdiction to enforce the law. And in this particular instance, although it was a well-intended statute, the way it was written, it made it impossible to enforce. So what I had in my particular case, a young girl was involved in a sexting charge, and she received a notice to appear in county court, and it was prosecuted almost as if it was like a county ordinance violation. And I filed a motion to dismiss with the county court judge, explaining what the jurisdiction is of county court and this jurisdiction is of circuit court, and how this sexting offense doesn't qualify for either. And the judge agreed, and she dismissed the charge.
I've got a kind of a quick question on the sexting. Is there a difference in if it's text only or image only?
It doesn't differentiate between text or image. What it says, the statute basically says sexting occurs when someone shares nude or sexually explicit images with others through the use of cell phones, the internet, or any other device capable of transmitting data. So it's always going to be an image, but there might be some statements along with that, something that makes it sexually explicit.
And it doesn't have to be just a text message. It could be social media, email.
Correct. In this particular instance that I was involved in, and I don't want to get into the details too much, it actually involved the internet.
So the first offense is not a crime?
The first offense is not a crime.
Okay. The second one is?
The second one would be, yes.
Okay.
And again, it's designed to have it's prosecuted not the same way as, the serious felony of exploitation, or not exploitation, but exposure of sexual organ charge or lascivious exhibition. It's a little bit less serious, and obviously the intent behind that is to not throw a bunch of kids in this moniker of being sexual offenders.
Right.
That was the purpose behind the statute.
And just to be clear, minor is 18 and under, correct? Or under 18?
Under 18.
Under 18.
Got it.
Okay.
Got it.
All right. Well, good. Anything else on that, Mike?
No, I think that quite frankly, it was almost unfortunate. As a lawyer, you have a duty to represent your client and protect your client no matter what. So, when you do the research, you say, wow, that was a good intent. I appreciate where the legislature was coming from, but I've got to protect my client, and there's just no jurisdiction to prosecute. So it was dismissed. The unfortunate outcome of that is that leaves law enforcement with no other tools but the old tools that they had that this statute was enacted to prevent or go around. So it's kind of unfortunate, and I'm hopeful that the legislature takes some effort to amend that statute to make it at least enforceable, so we don't have 15 and 16-year-olds who make some silly mistakes in their lives being prosecuted as sexual offenders.
Right, for the rest of their lives. Correct.
There are certain things that can happen that, even though it's a juvenile crime.
Okay. All right. Well, you've been listening to the Bauer, Kreider, and Perry podcast. Never Believe You Can't Win. We were speaking to Mike Kinney, Tampa criminal defense attorney.
Thank you for listening to the FloridaDefense.com podcast. Our firm has over 130 years of combined legal defense experience. Strong defense, stronger results. Consultations are free. Visit FloridaDefense.com today.